Hello, I'm Jeff Sheridan. I'm a Minnesota DWI defense lawyer. I also practice in the area of criminal defense. So much of what goes on in Minnesota's DWI law happens in the shadows and is specifically designed to trick drivers into forfeiting important rights they have. So I've decided to do a series of videos that I'm calling Minnesota's Dirty Little DWI Secrets. I hope that you find these videos are helpful and informative. The topic of this video is, you can get a DWI for doing nothing more than following your doctor's orders. One of the many dirty tricks in Minnesota's bag is the DWI for having a detectable presence of Schedule 1 or Schedule 2 controlled substance in your system. Schedule 1 controlled substances are the street drugs that you hear about, like cocaine, heroin, methamphetamine, and the like. But Schedule 2 controlled substances, they cover a wide spectrum of substances, including many prescription medications. These include prescription pain medications, including those as innocuous as Tylenol 3, and almost all of the ADHD medications. The important thing to remember here is that you don't have to be under the influence of these medications, and that they need not have had any influence on your ability to drive. They simply have to be detectable in your system. This type of criminal charge generally gets brought when a person has been in some type of an accident, no matter how minor. The officer will always ask the driver, have you been drinking or using any drugs today? And of course the unsuspecting driver honestly replies, well, I haven't taken any drugs, but I have taken my medications. The officer then demands to see the prescription bottle, and pretty soon the driver is providing a sample of blood or urine. Again, it doesn't matter that the medication had nothing to do with the accident. It may be that the driver was actually hit by somebody else, but that is not going to save you from being charged and having your driver's license revoked. Now, you have a defense to this charge that you were using the medication as prescribed, but that is what we call an affirmative defense, and that means the defense is only available if you can prove it. The state doesn't have to prove that you didn't take your medication as prescribed. You must prove that you did. What that means is that the existence of a valid prescription is not going to save you from being charged and not going to save you from having your license revoked. It'll only save you when you can prove that you complied with the prescription to the judge or the jury. These cases are extremely tricky, and you will not be able to do it on your own. Your time to fight is also extremely limited. If you don't sue the state within 30 days of your license revocation, you can't ever do it. And the fact that your license was revoked for a DWI is going to be a permanent part of your driving record. Don't fall into this trap. Contact my office at the number on your screen for a free in-person consultation with me. There is no obligation, and I can assure you, you will come away from our meeting with a much better understanding of your situation, having lost nothing more than a little bit of your time. Call now or visit our website at www.ssdpa.com.